Well, hello everyone, and welcome back to AJ102 Introduction to Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week we are going to cover Chapter 10, where we're going to take a look at pretrial and trial procedures. So, we're going to kind of walk through the system and hit every part of what happens before a trial and then during and even after. So this chapter that we're going to go into right now reviews both the before trial, which is pre-trial, and the trial process, beginning with the some of the procedures. And pre-trial procedures are important components of the justice process because the vast majority of all criminal cases are resolved informally at this pretrial stage, and they never come before the court. And although the media, likes to focus on the elaborate jury trial with the dramatic elements and impressive setting, etc., formal criminal trials are relatively infrequent. Consequently, or as a result, understanding the events that take place during that pretrial period, the before trial, is essential in really understanding the reality of, criminal justice procedure, policy, etc. So what do we hope to learn? Well, we're going to discuss the procedures following an arrest. We're going to list a variety of bail systems, describe the history of bail reform, define pretrial services, meaning what are those things that come up before the trial, and list the differences between an indictment process and the information process. And just to give you a little bit of kind of hint, that's like a preliminary hearing, like a little mini trial, but we'll talk more about that. We're going to discuss the purpose of an arraignment. We'll talk about some pros and cons of plea bargaining, explain the roles of the actors, the prosecutor, defense attorney, judge, and victim in the plea bargaining process, explain the legal rights of the accused at trial, and then kind of summarize that whole trial process. So a lot to cover. Okay, so as I said before, pretrial procedures are, legal and administrative actions that take place after arrest and before trial. And this includes grand jury indictments, preliminary hearings, bail, and plea bargain negotiations. And the vast majority of all criminal cases are resolved informally at this particular stage, at this pretrial stage, and they never come before the courts. So what happens after the arrest? Well, after arrest, the accused individual is ordinarily taken to a police station where the police list the possible criminal charges against him or her and then obtain other information for the booking process. And, this may include, recording a description of the suspect and the circumstances of the offense. The suspect may be fingerprinted, photographed, and also required to possibly, take place in a lineup. So all of these different things are going to happen. And the arrestee is usually detained by the police until it's decided, basically, of whether the person will be formally booked and a criminal complaint is going to be filed. So we have the person's arrested, they're informed of the charges, etc. They could be photographed, fingerprinted, they could end up in a lineup. There could be statements made at the station, interviews, etc. But this all kind of happens after the arrest. And then at this particular part, in the process, the person, of course, is at the police station until it's decided if the person's going to be formally booked and a criminal complaint filed through the district attorney's office. Now, the complaint itself is the formal written document identifying the criminal charge, the date and place where the crime occurred, and the circumstances surrounding the arrest. The complaint is sworn to and signed under oath by the complainant, who's usually a police officer. The complaint will request that the defendant be present at an initial hearing held soon after the arrest is made. So the complaint is basically the officer files the report, they send it over to the DA, and then the complaint is filed. Okay? And that first thing that happens, that first initial hearing that's going to come up soon after the arrest, is going to be what we call the arraignment. And it could be different in different jurisdictions or different states, different jurisdictions. But in most jurisdictions, this next hearing is going to be what they call an arraignment. Now, the arraignment is the initial court appearance and is where the judge is going to inform the defendant of the charges, ensures that the defendant is properly represented by counsel, and determines if the defendant should be released on bail or some other form of release pending the next hearing or pending trial. And in a lot of jurisdictions, this is also where the defendant will enter a plea to the charges. Okay? And typically, it's going to be either guilty, not guilty, no contest. And these are some of the typical ones, and there could be others in different states, but I just kind of wanted you to know that here's some of the general ones, okay? Now, we're still talking about the procedures, following an arrest. Many important decisions about what happens to a defendant are made prior to trial after the complaint is filed. And hopefully that kind of makes sense, okay? And hearings such as before the grand jury and the preliminary hearing are held to determine if probable cause exists to charge the accused with the crime. So, after the complaint is filed and then after the arraignment where the person, enters a plea, they're notified of the charges, etc., in addition to those particular steps, there are going to be hearings before, either a grand jury or there's going to be a preliminary hearing to determine if probable cause exists to charge the person with the crime. And here's kind of a little, almost like a schematic that shows, what happens. So you have the complaint made by police officer or citizen, the complaint. So this is, they file the report, they make the arrest, they file the complaint, the DA issues the complaint, and then, or there's an arrest booking, you're either released on bail. If it's a misdemeanor, it goes here. If there's a felony, it goes through all of this stuff. Here's the preliminary hearing or a grand jury, or there's no, it's just, there's so many parts to the process. Now, as I said before, in addition to the steps in that pretrial phase, the defendant is also considered for bail so that they may remain in the community to prepare for their defense. Okay? And even at this early stage, some may, kind of enter court-based treatment programs, etc. We'll talk a little bit more about that. But bail is always one of those things that comes up at that first hearing that we talked about, which is the arraignment. Now, what is bail? It's a form of security, usually a sum of money that is put up or exchanged to secure the release of an arrested person before the trial begins. And the bail amount serves as basically a bond, ensuring that that released individual is going to come back at trial. And if you don't come back, if you fail to appear or return, you forfeit the bail. And you probably have all watched, Dog the Bounty Hunter. And those are bail enforcement. That's what they do for a career. They're bail bonds, folks. But these are bail enforcement individuals. And they go out and they look for those people that have skipped bail. Now, the majority of criminal defendants are released on bail prior to trial. Not all. It just really depends a lot on the severity of the crime, etc. So, whether a defendant can be expected to appear at the next stage of the criminal proceedings is kind of a key in determining bail. Bail's not supposed to be used to punish an individual. It can't be denied or revoked at the indulgence of the court. Bail, as I said, is a critical stage in the justice process and a key ingredient of what we call fair and equitable adjudication processes. It enables people charged with a crime to be free in the community in order to prepare for their defense. And that's one of the major, foundations, if you will, of bail. Now, bail's not a new thing. In England, the practice at the time of the drafting of the U.S. Constitution was that people who had been arrested and who were awaiting trial could be released from detention by depositing money or title to property with the court. And then a failure to report to court would result, of course, in the forfeiture of that money or that property. And as time evolved, it's kind of led to what we now call posting bail. And typically, most individuals will go to what they call a bail bonds company. You can see the pictures on the screen right there. And they come up with 10% is typically what it is. They need the cash of 10% of whatever the bail amount is going to be. And again, if they skip, then they forfeit that particular 10%. So how does bail kind of tie in with, the Bill of Rights or the Eighth Amendment? Because the Eighth Amendment talks about bail, cruel and unusual punishment, etc. So, bail was incorporated into the Eighth Amendment of the U.S. Constitution, but only insofar as it prohibits, quote, cruel and unusual, end quote, punishment and excessive bail. So again, there's no constitutional right to bail. Bail can't be used, as I said a moment ago, as a punishment or a mechanism to coerce or threaten a defendant. And the U.S. Supreme Court's interpretation of the Eighth Amendment's provisions on bail was set out in a case called Stack versus Boyle in 1951. So, yeah, quite some time ago. In this particular case, the court found bail to be a traditional right to freedom before trial that permits, unhampered preparation of a defense and prevents the criminal defendant from being punished prior to conviction. So, but as a little note that I put down here, just remember the primary purpose of bail is to ensure that the defendant comes back for trial, but we know that that doesn't always happen. And then, the court here also in the case Stack versus Boyle held that bail is excessive when it exceeds an amount reasonably calculated to ensure that the defendant is going to come back or return. So the court indicated that bail should be in the amount that is generally set for similar offenses, and higher bail can be imposed when evidence supporting the increase is brought forth. So kind of a little history lesson on bail. Now, as I said a moment ago, a majority of criminal defendants are released prior to trial. And the most recent surveys of pretrial release practices show that about 2/3 of felony defendants are released prior to the final disposition of their case. And bail is typically considered a court hearing conducted shortly after a person has been taken into custody. A lot of times, remember, at what hearing? Not always, but usually at the arraignment, bail will be set. Okay. And at that hearing, whether it's a separate bail hearing or the arraignment, okay, it could be either one. At that hearing, such issues as the crime type, flight risk, the dangerousness of the crime or the individual, prior record, and victim input are considered before a bail amount is actually set. So again, interesting, facts as it relates to bail. So what then would be some alternative bail release mechanisms? So although bail is typically granted during a court hearing, there are other, stages would be a good word for it, in the system, or processes in the system in which bail may be granted. And the first could be a police field citation release, which is basically an arresting officer releases an arrested person on a written promise to appear, a ticket, typically for misdemeanors only. Okay. And on the ticket, it's kind of like if you got a traffic ticket, but it's going to be for a section, a violation of a criminal section, etc. And it's a written promise to appear in court. And again, typically it's used for misdemeanor charges, etc. There's something called a police station house citation release. So the determination of an arrestee's eligibility and suitability for release and the actual release of the arrestee are basically deferred until he or she has been removed from the scene of an arrest and brought to the station house or police headquarters. Okay, so this is a station house release where you're going to get a citation release, but not in the field, right? It's going to be back at the station, and we're going to determine whether or not you are okay to be released, and you'll be released from police headquarters. Then there's a police pretrial jail citation release. And here the determination of an arrestee's eligibility and suitability for citation release and the actual release of the arrestee are deferred until after he or she has been delivered by the arresting department to jail or other pretrial detention facility for screening, booking, and admission. And what this basically means is you're in custody at the station, you're going to get booked, and you're going to be sent to the local county jail, but there you're going to get site released. But you're going to go through that whole process of being booked, etc. So you do the facility screening, the booking, and admission into that particular system, and then you will be site released. Okay, another one would be pretrial court direct release by pretrial bail program. And I know this is a lot of interesting stuff that maybe you never heard of. So to streamline, release processes and reduce lengthy stays in detention and pretrial program, courts may authorize pretrial programs to release a defendant without direct judicial involvement. So this would be certain circumstances. And when the court, rules delegate such authority, the practice is generally limited to misdemeanors, but a few felony release authorities have been granted. And then finally, you have the police/court bail schedule. And here an arrestee can do what we call post bail at the station or jail, county jail, etc., according to the amount specified in a bail schedule. And the schedule is basically a list of all bailable charges and corresponding dollar amounts. And these schedules can vary widely from jurisdiction to jurisdiction. And they come in, like a little booklet. Here's, Superior Court of the County of Los Angeles. This is their 2021 felony bail schedule. And here are the amounts. I took just like a little snippet. So for robbery, first degree, the bail is $100,000. Now there could be enhancements, etc. But you can see these are the kind of the bottom part of the bail schedule, and enhancements could actually make the bail schedule higher. So hopefully these other mechanisms kind of make sense, and you can find them in your textbook on, I believe, pages 383 and 384. All right, so what are some types? So remember, these are mechanisms. These are alternative bail release mechanisms These are the types of bail. So there are a variety of ways or mechanisms to secure bail depending on the jurisdiction, the crime, and the defendant. First would be full cash bail. This is you pay the full amount of the bail, okay, kind of out of pocket. And in some jurisdictions, property can be pledged instead of cash. There's what they call deposit bail, and this is typically the one that we see. Where I remember I talked about the 10%, or 10% with a bail bondsman. Actually, that might be a little bit later, but this is deposit bail. The defendant basically deposits a percentage of the bail amount, typically 10%, with the court. And when the defendant appears in court, the deposit is returned. There's basically surety bail, and this is where the defendant pays a percentage of the bond, usually 10%, to a bonding agent. So this is one that typically is the bail bond, okay, who posts the full amount. So you go to your bail bond place. If the bail is, $100,000, then you have to come up with the 10%, and then they post the rest, okay? And the fee is paid to the bonding agent, is not returned if he or she, fails to appear in court, etc. There's conditional bail, and here's where the defendant is released after promising to abide by some specific condition in lieu of cash. Maybe it's a program or something similar, like maybe you promise to participate and complete or attend a treatment program. There's unsecured bond, where the defendant is released with no immediate requirements of payment. If the defendant fails to appear, he or she is liable for the full amount. And then finally, we have what we call OR, or released on recognizance, own recognizance for short. And this is, not everybody, but eligible defendants are released without bail, just on their promise to return to court or to trial. So those are different types of bail. And here you can see a couple of different things that we talked about, the type of pretrial release. And you have the surety bond. This is to the bail bondsman folks, remember? And then here's the own recognizance. So you can see this one is number 1, OR is number 2, and then it kind of goes all the way down. But just a little chart that you can see that basically looked at felony defendants in the 75 largest counties in 2009, and here's kind of some of the information that they want to show us about pretrial release and bail. And here are some median bail amounts by crime. And again, remember, each jurisdiction a lot of times will have that bail booklet, and that's typically what the courts will go by. Okay, so now let's talk a little bit about pretrial detention. So the criminal defendant who is not eligible for bail or release on own recognizance, OR, is then subject to what they call pretrial detention in the local county jail. Now, unfortunately, the jail has long been a troubled spot for the criminal justice system because conditions tend to be a little bit poor, right? And rehabilitation not really where it needs to be. But again, so we're talking about people who are either denied bail or can't afford to post bail before trial. They're kept in secure confinement. Now, in terms of the number of persons, on any given day in the United States, nearly 750,000 people are held in approximately 3,200 local jails. And over the course of 1 year, many times this number passes, through the jailhouse door, if you will. About 60% of those held in local jails have been accused of a crime, but not yet convicted, because remember the phrase for them is they're called pretrial detainees, those who are denied bail or can't afford to post bail they're kept in that secure confinement. So that's pretrial detention. And, we talked about the fact that jails are considered, kind of the weak link in the criminal justice system process. Many felons are transferred from prisons to jails due to overcrowding. And traditionally, they're most likely to be convicted and get longer sentences than those who commit similar crimes but are released on bail. So think about what I just said when it comes to, traditionally, pretrial detainees, right? Those that are denied bail or can't afford bail are more likely to be convicted and get longer sentences than those who commit similar crimes, but they are released on bail. And the question I would just kind of have you think about would be, why? Is it because they can't afford an attorney? Chances are if you can bail out, maybe you can afford your own attorney. There's different things for us to think about. Do they have more access to their attorney because they're out, or other people that they need to talk to get their case, their defense built up, right? And to work on that, versus if you're in jail, it's a little more, it's more difficult to work with your court-appointed attorney or even your private attorney. So a very interesting thought for us. Now, as far as bail reform goes, bail has been heavily criticized as one of the most unacceptable aspects of the criminal justice system, because some view it as discriminatory because it works against the poor, who have a much harder time making bail, which makes sense, right? And others argue it is costly because the government must pay to detain these offenders who are unable to make bail, but who would otherwise remain in the community. And then another problem is that effect, that legal effect, if you will, of detention. So it's kind of interesting when you think about that, right? If you can make bail and you can get out, that's great. But if you can't, is it more an economic thing? Or if we let you out, are you going to commit more crimes? So a lot of times there's some discretion on the part of the judges, etc., as it relates to bail. So as we talked about the fact that bail has been criticized as one of the most unacceptable aspects of the criminal justice system, let's talk a little bit more about bail reform. So most states place no precise limit, if you will, on the amount of bail that a judge may impose. People charged with the most serious crimes usually receive the highest amount of bail, and that kind of makes sense. Now, efforts have been made to reform and even eliminate money bail, okay, and reduce the importance of bonding agents. Until the, early 1960s, the justice system relied primarily on money bonds as the principal form of pretrial release, and many states now allow defendants to be released without any money bail. And again, as we said, this is known as the release on own recognizance, or 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 ROR. So, along with that, efforts to tighten bail restrictions on the most dangerous offenders is also in play. So, it kind of makes sense. Now, again, we talked about ROR and the fact that many states are working to eliminate cash bail. The California Supreme Court has eliminated cash bail for defendants who can't afford it. And they wrote this particular quote, writing that conditioning freedom solely on whether an arrestee can afford bail is unconstitutional. Now, in California, the state Supreme Court has ruled to end cash bail if a defendant can't afford to pay their bail. And some people agree with this and some people don't. Well then, what if they are super dangerous? What do we do with them then? So there's something called preventative detention. So whereas bail reform efforts are typically aimed at basically liberalizing bail, there are also efforts again to tighten those bail restrictions on the most dangerous offenders. And the reason is the fear that serious criminals may reoffend within the community. And these fears are a lot of times not unfounded. Nearly 10% of those, released prior to their trials on violent offenses or charges were rearrested on felony charges. And, we call these individuals avertible recidivists. And this is a person whose crime would have been prevented if he or she had not been given that discretionary release and instead had been kept behind bars, right? And then there's the other term called preventative detention. So one response to the alleged failure of the bail system to protect citizens is the adoption of preventative detention statutes. And these laws require that certain dangerous individuals be confined before trial for their own protection and that of the community. Now, preventative detention is an important manifestation of the crime control perspective on justice, because it favors the use of incapacitation to control the future behavior of suspected criminals. So just a little criminology tidbit for you there. Okay, so we've kind of hit a lot of different subjects, and we're going to go just through a few more before we take our kind of middle of the chapter break, if you will. So we're going to talk now about pretrial services. What are those things that you see pre-trial? So in our overburdened court system, it is critical to determine which defendants can safely be released on bail pending trial. And in many jurisdictions, specialized pretrial services can help. And pretrial services are programs that provide several services to those released into the community prior to their trial dates. And these services might include the following: gathering and verifying information about the arrestees, including criminal history, current status in the criminal justice system, address, employment, history of drug, alcohol abuse, etc. Assessing the likelihood of failure to appear or rearrest. Provide supervision for defendants. So basically providing supervision for defendants conditionally released and notifying the court of any failure to comply with these particular conditions. So, virtually all larger jurisdictions in the United States have pretrial release services in one form or another. All right, so now we're going to talk about charging the defendant. So charging a defendant with a crime is at a critical stage in the pretrial process. And the charge is selected by the prosecutor, who takes into consideration the facts of the case, the strength of the evidence, availability of witnesses, and so on. And this process, again, might vary depending upon whether it occurs via what they call a grand jury indictment or a preliminary hearing. And we're going to talk a little bit about these two items, and then we'll probably take our first break. So the grand jury was thought to have originated in 1166 in the Assize Court of Clarendon. And the assize was composed of what they called 12 good and lawful men who were appointed in each community and who were responsible for apprehending and presenting persons responsible for the commission of crimes to the royal courts. And yes, this course kind of, it evolved. And at the adoption of the Fifth Amendment, it says every state required indictment for felonies before a grand jury. And some states still use this. And, some counties, some cities, etc., they still use this grand jury indictment. Now, the importance of the grand jury in the political philosophy of the drafters of the Constitution is indicated again by the fact the Fifth Amendment provides that no person shall be held to answer for a capital crime unless indicted by a grand jury. So, ordinarily, this grand jury is going to be made up of 16 to 23 different members. So, by definition, an indictment, a written accusation returned by a grand jury charging a person with a specified crime after determination of probable cause. Okay, so that's kind of, what a grand jury does, if you will. Now, there was a Supreme Court case that came up as a result of the fact that of a challenge saying that, hey, I should be tried by, or there should be probable cause formed by a grand jury. There was a case called Hurtado versus California. And here the U.S. Supreme Court addressed whether states are required to provide a grand jury indictment. And the outcome of this case was no, states have another alternative. Basically, the state can use a grand jury or hold what they call a preliminary hearing. And they're almost kind of the same. Not quite, but they're kind of the same. Okay? So keep in mind. So preliminary hearing is like a little hearing to determine if there's enough probable cause to hold a person for trial. A grand jury is a written accusation returned by people, assigned to the grand jury, charging a person with a crime after determining probable cause. So it's almost the same as a preliminary hearing, but in a preliminary hearing, the judge decides, is there enough probable cause to hold this person over for trial? So two methods, okay? Grand jury or preliminary hearing. So a little more on the grand jury. The grand jury today has two roles. First, it has the power to act as an independent investigative body. In this capacity, it examines the possibility of criminal activity. And after completing the investigation, the grand jury issues a report called a presentment, which contains its findings and a recommendation of indictment. And I already gave you the definition of an indictment. So, the grand jury's second and better known role is that of being accusatory, because after examining the evidence and testimony, the grand jury decides whether there's probable cause for prosecution. If it does, an indictment is issued and it's called a true bill, which means the indictment is affirmed. If it does not, they issue a no bill, which means that there's not enough probable cause. Okay? And it looks like this. This is actually Michael Vick's indictment for animal cruelty. It's just it's the front page and the very back page. But I want you to see what an indictment looks like. And in the back, it says, after everything's listed in this report, it says a true bill, which means what? Which means that the indictment is affirmed, and we believe as a grand jury that there's enough probable cause to indict this person and move forward to trial. That's the grand jury. And then again, the preliminary hearing, again, we're hitting this hard because I want you to understand the purpose of this preliminary hearing is to require the prosecutor to present the case so the judge, kind of a mini trial, small, so the judge can determine whether the defendant should be held to answer to the charge against him or her. And by definition, it's a hearing before a judge where the grand jury is a hearing before the grand jury. To determine whether the government has sufficient evidence to show probable cause, the grand jury decides if there's probable cause. You see how they're similar but different? That the defendant committed the crime. Preliminary hearings are used in about half of all the states as an alternative to the grand jury. So similar, but not. So that's a grand jury versus an indictment. So quite a bit of information. All right, we'll finish up with this. The preliminary hearing, again, is conducted before a judge and is open to the public unless the defendant requests otherwise. Here again, present at the hearing are going to be the prosecuting attorney, the defendant's counsel, and the defendant. The prosecution will present not all of its evidence, but some evidence and some witnesses to the judge. Defense has the right to cross-examine the witnesses and to challenge the evidence. Okay, so it's kind of like a little mini baby trial. And then the judge decides, hey, the outcome. If the judge believes there's sufficient evidence, he or she can hold the defendant over for trial, and the prosecutor's information is filed. Information equals formal charges. If the judge does not find sufficient evidence, the defendant is released. And then there is something called waiving the preliminary hearing. A unique aspect of the preliminary hearing is the defendant's right to waive it. We don't want to go through the little mini trial. We want to skip it. And we want to go right to the trial. So here's a little thing on, again, charging the defendant, grand jury, preliminary hearing. All right, that's going to end part 1, and we'll be back in a few minutes for part 2.